Time.
Judge Gonzalez.
Thank you very much, Mr. Chairman. First, an observation. I was a big proponent of mediation when I was a trial judge in Texas, and we had this incredibly successful mediator. And so I asked him once, I just said, what is the secret? What is the secret of getting these warring parties that argue in court and you get settlements? He said, Charlie, it's really simple. If I can devise a way that all parties make money, cases settle. I think we have a situation today where all parties make money. But Ms. Peters has observed that it's just not the parties that are involved here. There's public interest. And there's ongoing, Professor Picker, certain principles that we recognize. Mr. Balto, we even copyright, antitrust. That's why we're having this hearing. It's not just about parties getting together and saying, can we reach some agreement where we all have some advantage? We know how that works. But it's bigger than Google, bigger than the parties. So what I want to ask Mr. Drummond, the genesis of this whole lawsuit, which is very interesting, it was doing something good for mankind. And that was to make books available to the children in the schoolyards and to those that are vision impaired and so on. And that's noble and that's wonderful. But you're also a business. So I suspect that there had to be some sort of a business model associated with this. You're going to go ahead and scan the entire books, but under fair use, you're only use snippets, which is a whole lot like being a little bit pregnant when it comes to copyright law. My question to you is this. When you envision Google Book and the business model, and before this lawsuit, did you entertain the following? That you would have and be part of and be central to institutional subscriptions? Just yes or no?
When we originally started the
before you got
scanning.
before you made party to a lawsuit, was it your intention to have some sort of rights conferred? And I'll just go over the list that's been provided to the committee as part of the memo. And the memo doesn't take any sides, it's just very thorough, and I commend staff. Listed below are various potential revenue streams for Google as identified within the settlement stemming from Google Print. Institutional subscriptions, consumer purchases, advertising uses, public access service, print on demand, custom publishing, PDF downloads, consumer subscription model, summaries, abstracts, compilations of books. That's what you're going to end up with at a minimum.
Sure.
I bet you guys are saying, thank God we got sued. Because I don't think you'd end up with any of this under what your original concern was. So my point is, and I know the benefits of Google, and I have to be with Professor Picker. We have to have this disclaimer. We love you, Guy, and everything, and then we come and we ask these questions. But it is, we use you, we love you, you're the best at it. But that doesn't mean that you can act in a way that, in fact, may impact competition. This reminds me of Microsoft a few years ago. Remember, because of technology, the law's not keeping up with it. Forget about these legal principles. Can't make the adjustments timely and so on. So let's just have temporary monopolies. Remember? Don't y'all remember that argument? It's a great argument. And I think we're always going to have it. I'm not real sure this is really the model to be used as technology moves forward and maybe Congress doesn't act quick enough and the courts move in. But what I'm saying to you, Mr. Drummond, does this in fact place Google at such a tremendous advantage in disregard of what has been historically copyright law? Prospectively, you don't have to do anything on orphan works. I don't think you have to try to find anybody and get permission. We understand that. But also, from a business model and the antitrust concerns that this committee should have in mind, how do you respond to those concerns?
Sure. No, we don't think it puts us in a huge advantage. Again, you got to step back and remember what this market is. Electronic books, out-of-print books, which is what the settlement is largely covering, are not driving the electronic book market. It's in-print books. And we have, as of today, we have zero market share in any sort of books. So we're a new entrant to the market. So far from being someone who's controlling the market, we're not even in it yet, and we're trying to get in there. and get in there and compete with some of the existing players. It's an emerging market. We think it's going to be very competitive, and there'll be lots of players and lots of different models. So we don't believe that this is giving us, what we have is a settlement of a particular lawsuit that was brought against us, being settled under a pretty well-established set of rules governing class actions, with lots and lots of opt-out ability and flexibility for the rights holders, and lots and complete ability for them to go deal with others. And to the extent that there's a concern that truly orphan works that are going to be available to Google won't be available to others, certainly we support Congress going in and legislating around that. And as I've announced here today, we're going to allow anybody to resell those orphaned works that we have access to.
But you're the
settlement,
gatekeeper,
including all of our competitors.
But you'll still be the gatekeeper. You still get a cut.
Well, we have a cut, but we'll give more of the money to someone else, and they won't have to pay for digitization, and they won't have to pay to host it.
And you got the cut?
Excuse me?
Would you mind if there was another gatekeeper and you got a cut? Wait.
That happens in our business all the time. We have revenue shares. We work with partners, and we work through other partners. That's pretty common practice on the internet. So,
on this scale, as it comes to copyrighted material, I don't believe that really does exist. But I guess what I'm saying is this lawsuit went beyond what was the real issue here. And I understand there are financial advantages to some, and thank God for the writers and everybody else out there. But I just think this goes way beyond what was intended. If you had gotten permission to scan books and use snippets as part of searches and such, that should have settled the entire case, I would have imagined. But we're way beyond that now. And thank you very much for your indulgence, Mr. Chairman.
Thank you very much. From California, Mr. Brad Sherman.
Thank you, Mr. Chairman. I think we need to take a step back and just think of how wonderful it is that we're going to see 100 million books available in every village on this planet. Chiefly the private sector has developed the internet, and we need to make sure that this additional and huge chunk of information is available on the internet. We ought to give a high priority to moving legislation in this area. It's been suggested that we provide to other firms the rights that Google has under this settlement. Surprisingly, Google seems to be the chief advocate of this. Mr. Meisner, would you object to legislation that codified this agreement and allowed other responsible parties to do exactly what Google is doing on their own?
Instead of the settlement?
It would, I don't know whether it'd be instead or addition or superseding.
Certainly not in addition to, because this would give them a temporary, how long is it, a few months advantage at the very best. But
well, if everybody at the table agreed on the legislation, that's why we have suspension bills.
Okay. I'm happy to support legislation as we have for years. We would be happy to support this orphan works legislation to get at this problem. But we will not agree to a circumstance in which one company gets an exclusive opt-out copyright regime while everyone else waits for legislation. There are other problems with this proposed settlement, Mr. Sherman. I mean,
well,
it's not just
you could probably move the legislation pretty quickly, and you could probably delay the settlement. You've got some lawyers. Moving along, you're focusing on the orphan works. What is Amazon doing, and what is it planning to do with respect to making orphan works available? What effort is Amazon making to scan out-of-print books?
We're complying with the law.
Well, so am I, but I haven't done a damn thing to make out-of-print books available.
That's true. That's true. That's pretty funny. But we have scanned 3 million books. So we've been at the scanning business longer than Google has, and we're very pleased with our efforts. But in each case, we've gone out one by one and